Hello, my name is Jennifer Kessinger, and I teach resource and algebra in a high school alternative program. I have experience in a variety of settings, but I am exactly where I should be, and I truly love what I do. Today I'm going to share with you the results of a case of Fales versus Garst. This case was filed by 3 middle school teachers against their administrator at West Fork Middle School in West Fork, Arkansas. The case was filed in June of 2000. The complaints were made about the care of students in the special education program and the treatment of the teachers who had stood up for them. Dr. Jacqueline Fales, Mary Ann Common, and Eileen Scarborough charged Lynn Garst with violating their First Amendment rights by ordering them to not discuss issues in the school's special education classrooms. He also violated their 14th Amendment rights by lowering their evaluations when they took their complaints over his head to the head of the special ed department and a superintendent. The court looked at these charges, and after considering them, the case was sent to trial. They decided to proceed. So Mr. Garst countered by filing an appeal with the U.S. Court of Appeals for the 8th District. His appeal asked for a summary judgment, which meant that there would be no trial. They would just come to a decision without the trial. And that would come on the grounds that he was entitled to qualified immunity, which meant that because he was a government employee, he could not personally be sued for things that happened on the job. There were many accounts that the teachers had listed in the court case. Things such as being ordered to not discuss student situations with anyone but the administrator. There were repercussions for those teachers going to the head of special ed and to the superintendent. He eliminated mandatory planning periods for one of the teachers. Ordered them to only bring concerns to him and to not discuss anything with anyone else. The decision was made. He made decisions in disregard of the special education law, such as having students stay home when he had other things for the teachers to be doing. He wanted to have the right to decide what the IEPs would look like, even though that should be a team decision. And he also decreased their evaluation scores because of the actions of the teachers going over his head and disagreeing with him. So the U.S. District Court, which is where the case was initially filed, ruled that Lynn Garst did not have the right of qualified immunity and decided that the trial would move forward. When that took place, as I had said, he filed an appeal for that, and the U.S. Court of Appeals overturned the district court's decision, which gave Lynn Garst the immunity, and the case was dropped. It was sent back to the U.S. District Court and had to be dropped. The benefits that this has had for special education, the impact is that when the U.S. District Court allowed the trial to begin, that left the doors open for future litigation for student advocates. So it did not close down the fact that if teachers are in disagreement with their administration or their school district or their schools, if they know that the rights of the students are being violated or that the right thing is not being done for those students, there is an accountability that they can take that administrator or that district to court to fight for those students. And so looking to the future, there will hopefully be more protection for teachers who stand up for the rights of the special education students, and we will see a tilting of that balance to where the importance of what is right for the students ends up coming out on top. Thank you for listening.